So, so in this video, we're following up on the previous video that we did on the basics of trademark. We're going to talk about names as trademarks, so essentially words. And we're going to talk a little bit about what are the different kinds of words and which ones what can be afforded trademark protection and what type of words cannot be afforded trademark protection. So there are four categories. The first one is generic. So a generic word cannot be given protection. So as you can imagine, the word apple cannot be given trademark for apples. It would make no sense to let someone use the word that is generically describing that thing as their exclusive name. The next one is descriptive. So descriptive marks or names are those where they are describing a characteristic or feature or quality of the goods or services. For example, 6-string guitar would be descriptive, or speedy delivery service would be descriptive. So in the case of descriptive marks, they can be registered only if they have acquired secondary meaning, which means that the consumers have already come to identify this descriptive mark as that brand. So unlike generic, where it's just not possible to get the trademark, even if for whatever reason everybody knows you as the one providing that good or service, for descriptive marks, you can get it registered if you've acquired secondary meaning. So for example, marked for science was a mark where they considered, if you look at the trademark, they said that it's descriptive, but the public had already come to associate it as that particular march, not just any march for science, but that company. So when they were putting on a march for science, people knew that it was going to be that group. So they were able to get the trademark. So the thing to keep in mind is that if you're trying to get your descriptive mark registered based on the secondary meaning, you're going to need an attorney and it's going to cost money because you're likely to get an objection from the trademark office. It's going to be their objections are called office actions. It is possible that the trademark office will research and see that it has acquired secondary meaning, but it's unlikely. So they're likely going to give an office action saying can't register because it's descriptive, and then you'll have to do what's called a response to the office action and make an argument, provide evidence to prove that you have acquired secondary meaning, and you'll have to understand the law, and it's not as easy. You have to cite to cases and things like that. So when you're picking the name, you should keep that in mind and probably avoid it. You don't want to be in that situation of you've already spent the money, you've already become known, and now you have to go fight for it. Now, most likely by that point, you're hopefully doing better and you can afford to spend, $20,000 or $10,000, whatever it is, to get that approved. But then it may not get approved. And honestly, it will probably require better lawyers to get that approved. So you just don't want to be in that situation if you can avoid it. And that's why I'm doing this for you guys right now, to give you these ideas so you can avoid picking a name that's going to be challenging and put you in that position. The next category is suggestive. So suggestive is not describing it, but it might hint at it, or it makes people think of that. A really good example of a suggestive mark is Playboy for the magazine. Another one could be, for example, Jaguar for cars. As you can see, these are not describing the thing, but they kind of imply some characteristic of the goods and services. That is a mark that can be given trademark protection. It doesn't need secondary meaning, which is the thing about consumers having already come to identify it. But the strongest trademark is the last one, which is arbitrary and fanciful. Arbitrary and fanciful are in the same group in that they are the strongest, but they are not the same thing. Fanciful marks are ones that are made up, like for example, Xerox is made up, but arbitrary is one where the word exists, it's commonly known, but it's arbitrary for the goods and services. For example, Apple is the perfect example. That's a word, everybody knows the word, it's a generic word, but it's arbitrary with respect to computers. So it's actually a very strong mark as far as this analysis goes. So those are the strongest marks, but obviously there's a balancing act. You as the business person will know whether that makes sense for your company to use, to have it be totally arbitrary, because you're going to have to put more effort into telling people what the company is and what they do. Whereas if it's suggestive, that is a little bit easier, obviously. But this conversation just had to do with the strength of the mark and how easy it is to get it registered. We are going to do a separate video talking about other marks and competition and potential confusion and infringement with other marks, which is a whole nother basis that both the trademark office will take into account when they're deciding whether to let your mark be registered, and you should be thinking about as well before you pick your mark, because it will implicate potential infringement of other people's mark, which can be really costly. So stay tuned for the next video.